All right, we are recording. Janet, you are muted.
Sorry, I said, okay, thank you, Maddie.
You're welcome.
It is 12:31 on November 20th, 2025. This is a meeting of the Land Use Review Board. I am Janet Hurley. I will ask other board members to introduce themselves. Kirsten.
Kirsten Sultan.
Brooke.
Brooke Dingledine, and Janet, I think you misspoke. It's actually 2:31, not
What did I say?
12:31.
Oh,
12:31,
sorry.
I think.
Yes, thank you for pointing that out and catching it. Yes, it is 2:31. Alex.
Alex Weinhagen, hello.
Sarah.
Sarah Had, hi.
Thank you. Bear with me, I only have one screen, so I'm going to be poking around on one screen here to find things. Any agenda updates from board members? Okay, hearing none. And is that Thomas that has just arrived?
It is Thomas. No comments.
Okay, thank you, Thomas. No public comments then on non-agenda items, so we will move on to item D, discussion and possible action on appeals study report. Brooke, do you want to take it away?
Sure. Got a hand up first? Maddie?
No, sorry, my bad.
Yeah. Oh. I, in the last half hour, emailed you all two appendices for the report. I have been compiling all of the comments that we got. Mostly, well, I think everybody really is a stakeholder. Oh, maybe not. We had some lawyers chime in that were not actually stakeholders. And there's a lot of information. It's many pages, and we're going to have to just merge that PDF with the ultimate document. And then the final summary document that's been posted, it has, I don't know, 2 or 3 more board meetings that were added to it versus the one that's actually posted on the appeals website page. I thought that was important to provide. I may change the summary document simply because when I was going through it and preparing it to be PDF'd onto the report, it occurred to me that we had 3 board meetings that were really important up front in the beginning, like June and July time period. And the problem with that document is that it has a lot of links. So if you want to see like the notes of those board meetings to see what we said about the appeals study, you have to click a link, and that is not going to work if it's attached to this report. So there are a few critical things that I think are important for us to actually populate the text into that document. It's primarily just those 3 meetings, because that was really where we laid out the whole discussion about how we're proceeding, and I think it's important to have that in there. But other than that, I think that each of the comments, I tried to start on a new page because, you know, primarily what you see in that document is like an email, cover email that says, oh, I have something attached. It might have within the email some comments, but then you will see, you know, for the NRC or some of the housing folks, they actually had a separate letter that they put in there. The only thing that's missing is the A&R. A&R comments are in the document, in the actual report, but question whether you all want me to also include, when we were talking about ALJ model, and that got disregarded because it was like an extra step to have somebody hear it and then give a recommendation to the board. So we kind of pushed that aside, but A&R wrote page and a half or a page about how they did not want that particular model. Would you like me to include that with the comment in the comments section? I mean, it ended up being disregarded, so it's really not relevant, although it was information along the way. So just didn't know if you wanted me to include that. And then the other piece is the actual memo from the judiciary that is primarily cut and pasted into the report. But I think it is important to put that separate one in there. So the two questions, do we want the A&R position on the ALJ model? And then the second question I have is, should we just put them in with the other stakeholder things? Originally we had like a separate tab for it, but I don't think we need to do that. We can like put them in the front maybe of the document.
Brooks, you had your hand up and then it went down. Do you have something to say?
I have a comment, but Brooks asked two very specific questions and I don't want to distract us from her questions. So after we answer those, I will speak.
I'm not sure I see the necessity of the A&R comments on the administrative law judge stuff, since it's not really discussed in the report.
Agree.
We ran the report by them to make sure that they were satisfied with the representation. So I think we're good from A&R's perspective.
Sarah, Kirsten, you good on that? Yeah.
I would have tended to include it, but I'm okay with omitting it. I sort of defer to Brooke as the sort of person who's been compiling all of these things, and I presumably has a good sense of what, where to put what, etc. So.
Okay, thank you.
Thank you.
Yeah, I think it's far enough afield. We kind of buzzed by that and just didn't make sense. So I think we'll disregard it.
And then as for where to put it, you're asking whether it should be part of the stakeholder information, but the judiciary wasn't part of the stakeholder group, so.
Yeah, we kind of added them to it, and then I do have the
Okay.
comment from them because they pointed out the issue with the court jurisdiction and about deciding property rights. So
Okay.
if we're gonna cut out A&R, I think we'll just put the other judiciary letter in to that one grouping instead of creating yet another
Okay,
appendix.
Fine
Yeah.
with me.
yeah.
Mhm.
So Alex, did you wanna?
Yeah, so my comment or question was, do we really want all this in the report? The report's 50 pages and it looks like the appendices are going to be more. I'm relatively new to legislative reports, so I'm sure staff can disabuse me of the notion that they need to be short and to the point. But what is the necessity of including every single public comment and the level of information that's in these appendices? Not all of the appendices. I understand some of them are worthwhile, list of stakeholders, board rules, that sort of thing, but does the report appendices
My
need
answer
to
is
have all those comments?
I thought I was supposed to.
I know, and
That's all.
we're all doing this for the first time, Brooke, so I'm asking the question too. It seems like an awful lot, and I don't know that anyone's going to look at it, and they could just as easily ask us if we have an archive of it. But I defer to staff
So
on that.
I think we did do that with the forest products manufacturers report. We included all that kind of stuff in appendices.
Yeah.
And I can't remember, Kirsten, we talked about creating one PDF versus multi. What did we do?
So what happened with wood products was it had to be filed with the legislature as a single document. So and it was sort of discovered last minute that we couldn't include exhibits, as a link to the web page, that kind of thing. So we went ahead and compiled this very voluminous thing, which was the main body of the report itself, followed by all the attachments. And we have that, that's what was submitted with a cover letter, and then that's what we posted on our website, but we also have the much more abbreviated report only copy. That is a little, it's just a much smaller file size and would be presumably of the thing that's of interest to most users.
And that's on our website as well as a separate
Yes.
document. Yeah. Okay.
And what are we actually compelled to do? Because I'm going to tell you right now, if I'm writing a report, which I'm supposed to, or we are with Tier 3, there's no way you're going to be able to include all of the public comments. I have more public comments right now than the wood products and the appeals combined. And we're not even halfway through the Tier 3 project. By the time we get to the end of it, it'll be impossible.
Yep. Pete,
Yeah, and what I did was, this was only on the report. I mean, I got correspondence earlier on, but it was only once we posted the report that I included stuff.
I was just gonna ask
Yeah.
Pete whether he could shed some light on past practice and expectations of the legislature.
Yeah, I think, I don't think there's any obligation that we, include every comment that we've received in a report. Nor have we done that in the past.
Okay. Yeah, then I'm not sure that, I think we should compile them and keep them in our archives, but I'm not sure that we need to submit them. Sarah?
So could a happy medium be, I understand we can't just put a link in, but if we actually spelled out the link, like the specific URL of the link, that might be a way of providing it. We're not required to provide it, but it's there in case people want to see it.
I prefer to just include a message saying, to see the public comments related to this, contact the Land Use Review Board, and then
Yeah.
we can make them available.
Yeah, because links change, URLs change. That's the problem with them. I think that's why they don't want them.
Brooke, just so you know, I'm totally happy with everything you have in your appendices. You might tell from the way I'm commenting on this, it's more of like self-preservation for the Tier 3 work that I'm trying to help lead on. So you can keep it, all the public comments in that appendices. That I'm okay with that. I just wanted to raise the question because I don't want this to become the de facto standard that then becomes impossible to meet.
Gotcha.
And the
Yeah,
the
I
only
was
thing
just-
I'll add and let Rebecca or Jenny jump in here too, but Tier 3 also involves the rulemaking process, and there is a responsiveness summary of the comments that are received that's required in that process. It's been a while since I've looked at that piece, but so I'll defer to Rebecca or Jenny on that, but just another piece to keep in mind.
Becca?
Yes, good afternoon, everyone. In my experience, that the report is meant to summarize the comments you received. So you want to cover like the scope of what comments you've received, but you don't have to actually include the comments themselves. Like, so it's meant to summarize those. And of course, they're public records, so we retain those according to our retention records. So that would be my advice in this situation. With rulemaking, we also provide a chart that summarizes the different comments we received, and then we go a step further and say what our response is to those specific, like, do we make a change? Do we think it's not necessary? But in this case, with a report, it's really just meant to summarize what we've heard. And then, so you always are kind of giving that pro con and then what you do with that information.
And Rebecca, do we
Yes.
do we do that without like identifying the people, just saying like, here's the content of the comments. We heard, this side and that side, and describe the actual comments, but Like, do I need to still identify who was the
No,
speaker
I don't,
or
I mean,
something?
I guess it depends on the situation and on the nature. If you were to get comments from, I don't know if it seemed particularly relevant who made them, or it was someone that we were supposed to definitely speak with, then you might want to be specific about who made the comments. But I've seen generally that you just cover them, right? Like it's just like, the group discussed this, right? And some of the negative comments or some of the people against this said, and you didn't have to go into the specifics of the who, because it's more important the content of what is said. And then sometimes you need to get into like the actual objectors, or proponents, but generally I don't think it's necessary.
Okay. I think I may because for example, the housing advocates wanted a very strong voice to say what they wanted to say about the report. And I mean, it's probably going to be obvious, but I get what you're saying. I think I will
Right.
make a general, attribution.
Yeah, I think, Brooke, like the ones you received from the judiciary, like I personally would want to know what the judiciary said related, sorry about that, related to like appeals, right? Like, so there's some people that I think, not to say that some comments weren't as important, but there's some that, definitely you'd want to know what the people currently doing the appeals are saying. So yes, I think, right, it can be very helpful.
Sure. Okay, great. Thank you.
And
You're welcome.
I'm willing to let Brooke make her own determinations about what's best here. I don't feel like it's something that I need to review. So if we have this discussion now, do people feel like it's fine to let Brooke decide how she's going to deal with these compiled comments?
Yes,
Totally okay with me.
Yeah.
And like I said, Brooke, I'm fine with it just the way you have it, even though it's a lot. And if that's the way you would like it to go, we've been able to see it all, and I'm happy with it. If you want to excise certain parts based on our conversation right now, that's fine with me too. I'm like Janet, I'm happy to leave that discretion to you without me
Great.
having to look at it again.
Okay,
Agreed.
great.
Agreed.
Now,
So
Mhm.
Brooke, I'd like to talk a little bit about the board rules of appellate procedure appendix, I guess. Is it
Sure.
part of the appendix? It's appendix B,
Yeah.
maybe?
Yeah.
At some
Okay,
point. So
bring
I
it.
don't know what else you want to hit during this discussion, but I'd like to hit that.
Yeah,
Sarah?
definitely. Let's do what you guys want to do and focus
Okay.
on.
I also have, I think, just a couple of like wordsmithing things in the actual report to throw out that aren't in the appendices. So
And are they controversial, or can I just make them and
I
email
can
them and
very
make
quickly
them?
share my screen and review them.
Sure. Why don't you do that before I pull up the other part, and you can fast forward down to the rules. And by the
Alright.
way, I've gotten all the formatting under control except for one issue, so it's looking much better, and I don't have charts on different pages, so it's looking a lot better.
Hopefully you can see that page 15.
Yep.
So you have municipal zoning and planning appeals. I would just say municipal permit appeals. I think that's the first thing. And then I think I wanted to reflect that further down where you had under about sequential strategy and testing the waters. You had, while not required, securing a zoning permit first. Usually, at least my experience was that people did not go fully into getting a zoning permit. Sometimes it would be like a preliminary plat. They would test the waters on the municipal side first and get at least partially through the process. So I think what I said in my comments was How about if we use zoning as opposed to municipal in this area? And just say, well, not required, securing a municipal permit as opposed to zoning permit, and then that second sentence say municipal processes are generally simpler.
Sure.
So that was. I
Yeah,
wasn't
you
sure.
know, I think we were trying to use the terminology zoning just because that's more familiar to people, but yeah, it's, you know, it's really a
So-
larger universe, actually.
So, and to back up to Sarah's first point, can you back up, Sarah, to your first
Yep.
comment? Municipal planning and zoning. So our municipal zoning and planning is confusing because we're not going to be taking planning appeals. We're not going to be taking appeals of the select boards having adopted a plan, for instance. So,
That's true, yeah.
they
Yeah.
are zoning permit appeals.
Well,
I
but
just
like
wanted
there,
to clarify that.
but I think that there are like planning commissions that do,
Site
like
plan
site plan
review and
approvals.
subdivision review, but they're
Right.
still, they're not planning though. They're
Okay.
permits. So I would say municipal permits
Gotcha. So
or
planning,
municipal permit appeals. Yeah,
so planning is not the terminology that we should be using.
Right,
Okay,
right,
gotcha. Because
right.
I should probably do a word search on that because I think it might have snuck in elsewhere.
Mhm.
Because I was trying to get that notion of to capture all of them to be trying to be correct, but yeah, I gotcha.
All right, and then I had just one other quick wordsmith, which was down under board capacity and timing considerations. I know we've been saying a lot about deferred maintenance, but I think that maybe we could, instead of saying deferred maintenance here under board capacity, it might be better to just say to modernizing the program and aligning policy and procedure to the vision set forth in Act 1A1.
Yeah, I agree. I thought deferred maintenance was a little colloquial, I guess might be the word.
Gotcha.
So
Sure.
those were my two.
That's it. Okay.
So thank you.
Now, Kirsten sent me some, and I have not gotten to those yet because I was putting together all the comments today. So, but I will get to hers.
Dana, did
Unless
you
you
have
want to go
some?
over them, Kirsten.
I had, well, I did have the deferred maintenance one. I had given Brooke some that may still be on her list of including, just like something about the timing for housing projects is important, and I had given her, I had given you, Brooke, a rewording of that because it suggests that timing isn't important for other types of development, but it is. It's just that we're in a housing crisis, so timing is really important to get housing across the line, but it's not that housing is the only one that has that timing has implications for. So
Yeah, now did you catch it in this version? Because I know I changed it, but I just don't know
oh,
whether,
there were two places then.
okay, because or maybe I didn't get it into the version that I sent you guys. I can't remember because I kept working on it.
Yeah, I think there were two places, so maybe you changed it in one and I caught it in another. But
Yeah,
sorry,
there
I didn't print this last one, so I don't have hard copy right now, and my computer stopped recognizing a second monitor, so I only have one screen right now, and it's hard
Yeah,
to
I can,
find.
I can find it. Because I know
Okay.
exactly what you're talking about. I
Yeah.
think that I've changed it again because I think that I thought I was losing my mind. I was like, I swear to God, I thought I changed this.
Yeah,
So
yeah, I think there were two places.
I'm pretty sure it's the second one is fixed now. So
Yeah. So, so I didn't have any substantive comments on the draft. I just wanted to
You want to go to the rules?
better understand the rules and discuss them a little bit as a board.
You want to do that now, Janet, or do you want to get through
Sure.
Kirsten's
Well,
comments and my
let's-
comments?
Let's go through yours first, and I think Brooke said Kirsten provided hers to Brooke. And you know, insofar as these are sort of wordsmithing, I don't feel the need to, you know, to have that discussion in open session. I think we can leave it to Brooke and the suggester of the revision to sort of decide where to go with them. What do you think?
Totally
I
agree.
was,
Kirsten?
I would agree with that. Got like a echo. Hold on.
Yeah, can you mute
Yeah.
your?
Sorry about that. So I agree. I think that if it's minor wordsmithing, absolutely, I'm fine with that occurring, but, and most of the items that I sent to Brooke, which were, you know, in the order of less than 10, they fell into that category with, a couple exceptions that, you know, we can jump into that now or.
Let's do.
Yeah,
Okay,
go for it,
so-
Kirsten.
Well, and it's also a, you know, sort of discussion point of not, fully knowing like Brooke's own position on if the board takes appeals, as a recommendation and starts with the appeals of Act 250 permit decisions and JOs, and then as a phase 2 scope, and we've already talked about this, and I know you know where I, you know, stand on this. I think that phase 2 would encompass all housing statewide and not be, you know, everything in tier 1A and tier 1B housing. So my preference would be to have that identified in a very cursory way as a minority position in the report. If anyone else, you know, also has that position, which I think Brooke does, but I don't want to speak for her.
Yeah, what
About
Kirsten,
as a compromise, just saying that, you know, we can reassess a few years down the road, see how things are going, and, you know, the board could take more housing appeals if it makes sense at that point. And there is that blank in the latest version about checking back in, and when we would do that, you know, we could just make a statement to that effect regarding taking more housing appeals as well.
yeah, if you want, I can kind of portray, you know, there were two thoughts on how best to respond to the, you know, to be able to expedite housing. But I think you're right, Janet. I mean, that's going to probably unfold to us. I mean, what if there's nothing in tier 1 and there is a bunch of housing? I mean, I don't expect that, but you know what I'm saying? I think you're right.
Yeah.
If we can say that we have, you know, two approaches or two thoughts on it. But do you feel
Well-
okay with that, Kirsten, if we
Oh,
said,
I'm okay saying there's 2 options, but I don't know if the others are okay with that.
I'm not willing to go with a recommendation on that. I'm willing to go with a recommendation to take tier 1 appeals, but not all housing. So I think that as far as the recommendation goes, I'm fine where we are right now as it's drafted now. I'm also fine with putting something in the narrative that says we can reassess this. We can take more later. We can reassess this at some later date to see if we can take more.
Yeah, I'm just not on the same page with this item. I think it should be, you know, and I don't see the harm in, you know, notating this option in the report, and that's my preference.
Sarah?
So I think I would agree with Janet. I think we can reassess if there are only 2 or 3 tier 1A communities in all of Vermont. That might change, but right now it's hard to make that determination not knowing what we're looking at. And I think I think where I appreciate Brooke has sort of steered the report together is recognizing that with all these changing factors, here's where the majority of the board feels confident. And so I think that that is appropriate to say. I think if we get into minority opinions, I think you open up the can of worms for a lot of the rest of us to be expressing our opinions on very different things and the report to be like twice as long as it is. So I would say, I think Janet's proposal of reevaluating, I think strikes some, harmony there, and that's what I'd like to see, without us going into minority or dissenting opinions on different items.
Alex, do you have any thoughts on that?
I agree with you, Sarah and Janet, and would like to move on.
Okay. So should we talk about rules? Oh, no, Alex, you had some comments. Go ahead.
No, I wanted to make sure Kirsten had a chance to raise the non-wordsmithing issues. Was there another one, Kirsten, you wanted to raise?
Oh, well, the other one that was, fell into the category of non-wordsmithing, I actually had a chance to chat briefly with Brooke about is under the cost estimate, there was sort of item A, staffing, item B, technology costs, item 3. Sorry, I don't have the section in front of me, but I think Brooke will recall. Item 3 was sort of like ongoing maintenance costs, and it wasn't really clear to me what this item encompassed, nor was it specified what those sort of ongoing costs would be. And it just seemed too open-ended and undefined. And I think we need to be more specific with that item. If, I interpreted to me, this is sort of like program overhead on a continual basis. But it wasn't really clear to me, so I anticipate that it wouldn't be clear to the reader. People reading it would sort of have the same, wondering what that refers to.
Yeah,
Yeah,
I
and
sort of
I
assumed it to
agree.
be program
Yeah.
overhead, like, we have to have, we might
Offices.
need a little bit more square footage that we're leasing from BGS or something like that. So I'm
Yeah,
not
I'm
sure what
gonna-
it is.
Well, maybe.
Yeah, I'm
maybe
gonna
we-
clean that up a little bit and make it
Yeah.
a little more descriptive, but I want to touch base with Rachel to make sure I'm explaining it right.
Okay.
So
And
that's definitely on the
and
list to
that's-
fix.
That's another thing that I would be fine with you just cleaning up, talking to Rachel and moving forward with.
Me too.
I
Do
agree, and
others? Yeah.
I agree, and I had the same comment, Kirsten, so thanks for making it. I show it on page 41 of the red line draft. Section Roman numeral X11, 13, number 2, third bullet, and would note that the number under the first bullet regarding increased staffing requirements is also needs a little tweaking because it says that to add one administrative staff person, it's $192,000, and that's more than the $110,000 that is actually required to add that staff person. The rest of that cost is not just the staff person, but other elements. Well,
Yeah, that text is wrong. It was based on the other charts, so I have it marked to go back and fix, because I gotta figure out the math, right?
Great.
Definitely.
Kirsten, if that's your non-wordsmithing ones, can I go through mine real quick?
Yes, but before I forget, I want to offer to Brooke too, that if she needs a pair of eyes to just go through it one last time, final super clean copy before it goes in. I know we're not there yet with the board conversation, but I'm offering to be a proofreader if that would be of assistance. So, but yeah, I'm done with the non-wordsmith minor things.
Great.
Great, I'll dive in. I'll try to be quick. The executive summary on page 4 of the red line strikeout, I would recommend adding a sentence after the first one that says, see section 13 for the rationale behind each of the following recommendations. Just so that the reader, because let's be clear, many readers are only going to read this page. And I want them to jump from this page to section 13, because that's where we explain why we have each of these. Next substantive comment. And I'm not looking for a minority position, but I just want to state this again. So this is section 10, appeals board model. And you've removed all references to the hybrid review standard. And we're just going back to de novo with some mention of the due consideration to the lower tribunal, or I know Thomas had a question about that word, but so I just want to say I still prefer the hybrid review language you had in the prior draft, and I think I still like that. So I'm just curious if the rest of the board is on the same page that Brooke is on about just making it cleaner and simpler with de novo as what this report recommends.
Sorry, hold on.
Yeah, sorry. This is page 30 of the red line strikeout draft 4.1.
Sarah, can you call on people, because I want to look at my screen to so if somebody raises their hand, will you thanks.
Yep. No hands are raised, so.
Okay.
While Janet's looking, Kirsten, Sarah, do you have are you happy with the way Brooke has it in this most current draft with the de novo standard and jettisoning the this concept of a hybrid review?
So I think part of me wants to save this conversation until we get to the rules that Janet wanted to go through, because I think it's sort of linked
Okay,
in terms
I'm
of what we're doing.
happy to
But-
defer to that. I got other
Yeah.
comments I can move on to.
Yeah, that's a good point. It really is linked, because that's
Yeah.
where we got to delve into it if we're going to change it.
Yeah, so
I'll-
go ahead, Alex.
Yep, I'll move on. So on page 35, this is in section 10. You have the table showing the proposed goals for processing time for appeals to the board. And you had everything is struck out there. There's no numbers. So I was just suggesting, can you put the date ranges in that you had in a very earlier draft, which was I think like 90 to 120, and I just like those ranges and think that would be the appropriate thing to put in here, so that we don't pin ourselves to one number and we show that it is substantially less than the court's guidelines, but there is a range.
Yeah, and actually, I mean, I took him out because I kind of wanted to start from scratch and think about it. And I've looked at it from different methodologies, like, oh, let's sit down and try to figure out what a calendar schedule would be for the case. And then the other way that I looked at it was I just looked at their numbers, and I also thought about the fact that we are eliminating discovery. So let me share my screen, because this is what I ended up coming up with to run by you guys to see what your reaction is to this. Hold on, let me share. So I'm glad Annette is on this call, because I'm sort of thinking the oh gosh, I had the wrong chart up. Hold on a minute. Let me get back to the court. Okay, so this is what the court does with these different cases. Now, the Public Utility Commission, when they do telecom towers, They have in statute 180 days. That is the processing time they're supposed to, from when it's deemed complete, I believe, until a decision is issued. They're supposed to get those decisions out in 180 days. There's also 150 days nationally. But I kind of use that as a guidance for my thinking. And what I do is I went to these numbers and I said, all right, if we're going to eliminate discovery, how much time are we shaving off? And, we're talking about at least 3 months, if not 6 months for discovery. So I started to subtract numbers from this. I was like, all right, 90 days off of 360, we get, 270. And then if we're going to curtail motion practice and make that quicker, so the upshot is that I kind of looked at these numbers, tried to, subtract from the ones that were relevant, like municipal de novo, Act 250 de novo. And I thought, why don't we just do the 180 days? It's basically half what the court is doing. If we're actually going to eliminate discovery, why not create the same statutory goal that the PUC has for telecom cases? If we are going to do a de novo, show up, you don't get time to do discovery, you have to have your ducks in a row very quickly, and then just, like you guys were saying, come to a hearing. And then we give ourselves, 30 to 60 days to make that decision. It's 6 months.
It's better
So-
than, yeah.
So I just put in 180. I have no idea what to do with this on the record, Jazz, because,
Because
if you
of
can't get a
the
record, somebody's got,
transcription taking, was it 2 to 3 months?
that was like minimum delay kind of thing.
Can we put something in there like, put in 180 with an asterisk and say, disregarding the fact that it may take months to get transcriptions, something like that.
Or just say this is our goal after the record's complete.
Yeah.
Because you're going to get the record quickly in the other cases, but not in this one.
And then on the JO appeals, I see you've taken 30 days off.
Jenny, you have any opinion about whether JOs truly are quicker than permitting generally?
Currently,
It depends, right?
Yeah, it depends. I would have to really dive in because every particular case has its outlier reasons. I mean, I think JOs are more disposable by motions practice, which might make them seem faster. But I also know the environmental court lately has really been encouraging people to ditch the motion practice and go right to merits hearing. So
What do you think about an 180-day shot clock? Not to put you on the spot or anything, but
I mean, in that case, we really don't need a table. We can just say that, like the PUC, our goal will be 180 days or less.
I mean, I think if you think it's feasible for a permit appeal, it's feasible for a JO.
Okay, so I'll be the dissenting voice. I think these numbers should be smaller. I think that if you build it from the start of the filing the appeal through a hearing, it doesn't need to be 180 days. I would like to see ranges. I would like to see the jurisdictional opinion be a 120 to 180 day range, and I would like to see the non-JOs to have. I would love to have maybe a similar range, but I understand why they could take longer. So perhaps 150 to 180. I think that, I think we can do better. These are goals. They're not, law. But if everybody else is happy with 180, I won't die on the sword here. I'll go with that.
I mean, I still like the range myself too.
Yeah,
Right.
but I feel like that's too tight. It's not about how fast we can do it. I mean, you have to give parties the opportunity to get their stuff in and then respond. You know what I mean?
So
We
maybe
can do that.
talking about,
We can give them that opportunity within the time horizons that we outline. That is the beauty of this process, is that we can determine you get this many days to get your stuff in. You get this many days to file your appeal. You get this many days to request, an interested party be excluded. And I'm just trying to work it forward. I don't want to go into too many details, but like if we keep the 30 days to file the appeal, then I think we're talking about another 30 days to get interested parties in the door and potentially have anybody challenged at that point. Maybe that'll take a bit longer. So you got 30 days to file, you got 30 days to clean up who's in, and then 30 days to supply evidence in advance of a hearing. That puts us at the 90-day mark. And then we
are
hold
we
a hearing and
counting
we
the
issue a
30 days
decision.
to appeal?
No,
Yeah,
no.
I don't think we would count that first 30 days, Alex.
Gotcha.
Yeah,
All right.
from
Well, that just
whenever the appeal gets filed, that
Yeah.
would be the
right. So
starting
that
point.
just makes my case more, right? So once the appeal's filed, I'll give you 30 days to get the interested parties figured out, and anybody, who wants to appeal an interested party can do that. I'll give you another 30 days for limited motion practice. I'll give you another 30 days to get your evidence together for a hearing. We're at 90 days. The hearing happened, and then give us 30 days to render a decision. That's 120 days, I think. So I don't understand why we can't hit marks that are below 180, or at least
180.
start the range at 120 and then,
So-
say 120 to 180 or something like that.
So I know Janet put me in charge of calling on people to raise hands, so I was gonna raise my hand, but then I just would, at any rate. So I think what I wanted to say on this front is, I think what Alex is advocating for is something that we've built into all the other different things that we've been doing with guidance. So for instance, with the regional plans, we've given ourselves like a deadline of no more than 60 days, no more than 30 days. And so there's process guidelines there in terms of time. And I think that we could count up just what Alex was doing and provide a range, so that people would know that it needs to at least be however many days. Be any shorter just because of what Brooke was saying, that process. But if everybody followed the process very quickly to the T, what is that lower number? And so maybe this is just adding in a lower number using just what Alex is doing, that timeline, and then up to 180 days, but no more than 180 days. I think that's would square with the rest of a lot of what we're doing with our guidance.
I appreciate, all of the conversation, but I don't understand what the purpose of a lower number is for a range. I think a goal or a, one number, it's got to be shorter than this, makes more sense to me. Look, if there's a motion filed, Alex, it's not going to be disposed of in 30 days. You have to give at least,
So that's
two.
why I want to talk about the rules of appellate procedure.
Okay.
All right,
Yeah.
well, then we can skip over this as well if you like, and I'll defer again.
I mean, I have no problem with the lower number. I just don't think it's meaningful unless you're trying to like set an expectation, like, look, we're going to do it quicker, but
That is what I'm trying to do, for sure.
Yeah.
But
Okay.
Yeah.
I'll defer and we can continue. I'll try to finish up. The next item I had was in the scenarios under resources needed, which is section 11, which is on the same page, starts on page 35 of the draft. I've said this before, so if everybody else is on the other page, I'm fine to just move on, but I still don't think we need two scenarios. I still believe that we do not need another attorney to take tier 1A and 1B appeals from municipal decisions. I feel like we have an additional attorney, and in 3 years, we will be done most of the Act 181 business that compelled the legislature to provide us with that additional attorney. And I would just like the report to show one scenario, which is scenario 1, and that's a legal services specialist and the variety of costs related annually and one-time expenses for that and the database and so on and so forth. Is anybody else with me on that, or are we destined to show two scenarios with more money?
I would like to be with you, Alex. I just don't know that we can know that. And what I will do again is suggest a compromise and just reiterate that there are uncertainties about number of appeals and workload around them. And if, scenario 2 would be if there are, if needed, I don't know. I too would like to say that we could do this with what we have and a technician, but I don't know. And I don't know that we will know for a little while. So, maybe this is just a scenario with a higher number of appeals than we might anticipate. And we can revisit this at that blank date. Somebody at 10 Baldwin.
I agree with you, Janet. And, I also would hope and like to think that we wouldn't need additional attorneys, but it remains to be seen. And I think what you proposed is a good solution. I wanted to quickly mention back on the guidelines for appeal processing times. I agree it should just be one number. And I tend to think that decisions concerning appeals of JOs should be quicker than the deciding appeals of permit decisions. I just think they would tend to have, fewer parties and just be something that could be decided more quickly. So maybe that number could be 150. So that's just a thought if you do, if it's left as one table. But I feel like I'm fine with sort of where we are, and if we tweak them a little bit, like that's fine with me too.
Sarah?
I agree with you, Janet.
About sort of compromising and say scenario 2 isn't necessarily for if we take tier 1A and B, but if the workload is greater than what we expect under scenario 1.
So I was the one that brought that up, and if it sounds like I'm in the minority, and that's fine. So I don't want to make more work for Brooke. If everyone was already comfortable with the way Brooke couched scenarios 1 and 2, I'm fine with it staying the way it is.
No,
So she
I'm
doesn't have to invent
suggesting
more language.
I'm suggesting a change,
Okay.
Alex.
I
And
like
that is
Janet.
that scenario 1 is we can deal with the workload with just one person, and scenario 2 is we need another person, and the other person is a lawyer, and we won't know the answer to which it is until we check in with them in a few years. And so instead of labeling them as transfer of Act 250 on the top one and then transfer of Act 250 tier 1A, tier 1B housing, it's just scenario 1 and 2.
Does that make sense to you, Brooke?
Okay, so you want, oh, okay, so just,
And it's gonna
After
be based
check-in,
on, yeah,
so what should we say? Transfer of Act 250 and municipal, just like, I mean, it
Um,
is in the future for whatever it ends up being, right? Or possible, I don't know, what do we call it? We can worry about it. I'll figure it out and run it by you offline.
okay, okay.
Okay.
Somebody at 10 Baldwin?
That was me. So I guess maybe I misunderstood the suggested revision that Janet was describing, because if the scenario 1 and scenario 2 are presented as such, that means that the board taking only appeals of Act 250 decisions is unknown. We do not know if it's scenario 1 or 2, and I think we've had consensus around recognizing that we need the, technician, but we do not anticipate that we will need another attorney for Act 250 permit decisions only because of the resources that have already been allocated and that we anticipate being able to repurpose. So I think that we should.
So I think the scenario 1 is, I think that we just need to relabel them, because scenario 1 is Alex's scenario. Scenario 2 is a scenario whereby we do need another attorney. So it's not based on Act 250 appeals only. That's not what scenario 1 is. Scenario 1 is we know that we need this no matter what. And our recommendation is that we intend to take Act 250 appeals, and then we intend to take Tier 1 appeals. That could work under scenario 1. It might not. That's what I'm saying.
Right, it
So,
sounds like you're saying, Janet, that scenario 1 is a low volume of appeals
yes,
scenario, and scenario 2 is a high volume of appeals
yes,
scenario.
yes, yes. And it's not based on when we take more than just Act 250 appeals. That's a separate question, and we have suggested, a phased approach. That's separate. This isn't tied to the phases. It's tied to, what we learn in terms of volume of appeals and our workload. It might be that what our Act 181 duties are essentially done, but there are what did we call it? Deferred maintenance, that as a program and a board, we feel like we need to spend time on this, and we need the help of a lawyer to help get us through this. And it's been neglected for decades. And, we might keep responding to various executive orders that throw us for a loop. And, we might find that, yeah, we can't deal with the number of appeals that we're getting without another lawyer. I think it's just there are too many variables and too many unknowns. And I think scenario 1 is, let's see if we can make it work with the one, additional staffer that we know we will need. And scenario 2 is, if our workload is such and the appeals volume is such that we need another lawyer. Sarah?
So I'm wondering, because I don't like the low volume and high volume, and this is going to need wordsmithing. I'm wondering if this is something that we can agree to have Janet work with Brooke offline on some wordsmithing to get this over the finish line.
I'm fine with that.
thought throw it to Alex and Brooke.
Sure. Alex?
Yeah, I'm fine. I'm fine with leaving it just the way it is or wordsmithing it per Janet's suggestion.
Okay, I'll do it with Brooke.
Okay.
You're being too accommodating, Alex.
Okay, so my last substantive comment is on page 47, which is in the recommendations section. I forget which section that is, the Roman numeral. Oh, it's still section 13. Anyway, that section has recommendations for other actions to promote the efficient and effective adjudication of appeals. And the first one has to do with the executive order from this year. And I know we talked about this. And so again, please understand, I'm raising the issue because I thought of it, but if everyone else is on a different page, just keep going. So I don't know why we're including this. This is an executive order that's tied to one administration in one moment in time and is not based in law that the legislature who we're submitting this report to is responsible for. So why is this another action that we recommend in order to promote the efficient and effective adjudication of appeals? I think we ought to delete it.
I thought it was like really important. That's why I threw it in as number one, because it's like, look what we're doing. We're doing it right now to put these in the front of the queue. So,
Yeah,
I
it
mean,
didn't
it
come
is
from
a law
from
and
us.
executive.
It
Well,
didn't
but
come.
hang on.
It's not something we recommended. It's and it could evaporate before this report even sees the daylight, right? I mean, it's not going to, but this is something the governor could turn off and turn on at any moment.
Well, but right now we're submitting a report and this is the law. An executive order is the law. It just, there are some aspects of it that we're like, do you have authority to tell us to do this? I mean, whatever. If you guys don't want it in there, that's fine. I just thought it was like demonstrating that we are presently doing everything we can to try to make things quicker for permitting.
These
and
are
for
recommendations
housing.
to the legislature, presumably for statutory changes.
Okay. Yeah.
But Brooke, I'm happy leaving it in if everyone else wants it in. I just thought it didn't need to be there.
Yeah.
What do others think?
Somebody at 10 Baldwin might have a thought.
Yes, that's me again. So, I had a little bit the same initial reaction as Alex, but then I went back and read the statutory charge, and one of my wordsmithing edits or suggestions to Brooke was to expand the heading title to reflect the statutory charge, which is more than just appeals. And in rereading that, I do think that it's okay to include the board's, what the board is doing with this with respect to permitting efficiency and housing. And I think it's fine to include. I hear what you're saying, Alex, but I think it's noteworthy and not insignificant, and it arguably belongs in the report. So.
It's like updating Act 250 rules isn't anything that they're worried about. I mean, we're telling them what we're going to do to make it faster.
Mm-hmm.
Okay, good enough.
Trying to
I'm
get
done.
credit for what we did.
Yeah, I understand, Brooke. And I'm done. Go ahead, Janet.
Sarah, do you have an opinion on that?
Again, I think maybe this is a wordsmithing thing, and if Kirsten already had some language around wordsmithing, I think that might be best to offline wordsmith.
Okay. Okay, so can we go to Appendix B and talk about some of these procedures? And I'm interested to talk a little bit about subpoenas in the context of our commission hearings, but also appeals. And I'm from the municipal realm. We had hearings and we had appeals of the lower decisions, and we never had to compel anybody. I'm just wondering, what are the cases that we see where we have to have commissions compelling witnesses?
Someone doesn't want to come, you subpoena them. And
But
it,
who?
this
I
is a
mean,
provision this is a provision in the APA.
Yeah,
You have to be allowed to have that power. So if you're a lawyer, you have the ability to issue a subpoena. If you are not a lawyer, you're a pro se litigant, you have to ask the board or the district commission, for example, to issue the subpoena if you're not an actual court officer. It's just a power. It's used very infrequently. I can't think of
it's
a
used
time
infrequently. Okay,
I've never subpoenaed anybody.
okay.
Unless like there's some big deal thing about like an expert who you want to bring in that they discarded, or I don't know. Can't really think of.
Yeah, okay. Jenny, you had,
Oh.
I'm sorry, wait, Sarah first.
Okay.
So I was just gonna say, different municipal experience, as I am aware of some municipalities where municipal staff gets requested to attend hearings that can be neighbor versus neighbors, and unless they're subpoenaed, don't participate. So
Wow, okay.
that's just one of those that in terms of time and money and effort on municipal side. So you will have that. I've seen it before, and so I
Okay.
think we need this.
Okay, thanks. Jenny?
I just wanted to note that there is also a subpoena authority in our Act 250 rules. Yeah, like you're showing there, and I believe in statute as well, as a power of both the board and the commissions. And I'm generally agreeing with everyone that it's a power rarely used, but um I would
Yep.
I wouldn't hesitate. I would
Yep.
hesitate strongly to get rid of it.
Yeah, yep. Okay, and Ten Baldwin has a hand.
And that's me again. So I agree with everything that's been said, and I would note my observation that it's used almost, very, very rarely. I don't think in my almost 20 years in District 7, I had occasion to see that formally used, but I think that some participants know that it's there, and it just kind of maybe compels them to participate more informally. And I think it's a good tool. It could be a good tool. So I would
Okay.
leave it in.
Thank you. That was helpful for me, edifying. Maddie points out that we're over time, and I think we need this time. So I'm gonna ask Pete, are you and Kirsten available to stay if Maddie has to leave past 4:30? Okay, thank you.
Yes.
No problem.
So, and the next, the Rule 40, notice of appeal. And we don't, this is sort of edifying again. I just need to understand these things a little better, I guess. But if a notice of appeal is mistakenly filed with the tribunal appealed from, the appropriate officer of the tribunal shall note thereon the date on which it was received and shall promptly transmit it to the board. And it, I don't know, can we make that happen just by putting it in our rules? How are we going to educate every municipality in the state that they need to do this?
Well, this is this is what happens in the court rules now. And it's always been the case. And then when they went to electronic filing, there was even more confusion. In fact, I'm even guilty of filing in both locations because when we switched to electronic filing, it was like a little unclear, like who you paid, for example. So this is also, you know, Supreme Court. If you don't file at the Supreme Court, you file at the trial court, it goes up. So, you know, if there's a municipality that maybe doesn't know what they're supposed to be doing, it's going to come to light quickly. So I think it is important, and I think it's a safeguard that we have, as far as I can remember, in every appellate situation in Vermont.
Okay. Under service, I'm just wondering if the appellant could notify interested persons at the same time as the notice of appeal. Because it's not like interested persons aren't known, they're on the, you know, they're they're
Yeah,
already established.
Yeah, it depends on which one, because, you know, there's this process when it's a municipal appeal that the town has to provide the list of interested persons because they, I guess, double check abutters, and, you know, we've always gotten like a letter from them that says, this is who it is, this is who was at the hearing. And sometimes I've even gotten like a list of the sign-in sheet because they can't even read the names, and it's like up to us to figure it out, the appellant kind of thing. So I literally just followed Rule 5 on this.
Okay.
We can build something in for Act 250 to be able to do that, but I don't think we can make towns do it differently.
Okay. Yeah. Okay. And then under appeals on the record, there is the record on appeal shall consist of the original papers filed with the municipal panel, any writings or exhibits considered by the panel, and a copy of the electronic recording of the proceedings certified by the presiding officer of the municipal panel. And then within 30 days after the filing of the notice of appeal, the clerk or other appropriate officer of the municipal panel shall transmit the papers and exhibits filed to the clerk of the board in the manner provided. So.
Which section are you on? I'm lost. I forgot.
Oh, I'm sorry. H.
Where are you reading from?
H, appeals on the record.
Gotcha. All right.
So, I'm just wondering, because these are all things that a municipal panel or the municipality has to provide on their, well, not all of them.
This is only the little handful of on the record towns.
Oh, that's true. That's true.
And they know how to do it. And I didn't want
Yeah.
to change anything, so the only
Okay.
difference is they send it to us, not the court.
Okay. So this next section B,
Mhm.
there's some very lawyerly speech here that I wonder if we can convert to common English. It shall thereupon be the responsibility of the municipal panel to cause a transcript to be made. Do we have to use the very lawyerly speech, Alex?
I'm happy with lawyerly speech in that regard. It's kind of fun, or putting it in plain speak. My point was going to be that in this section, I brought this up at another meeting. Maybe again, I'm in the minority, but I don't feel that it's appropriate to burden the municipality with the production of the transcript once requested by an appellant. I think we talked about this. My suggestion last time was that this be changed so that the electronic record, which should exist, be made available to all parties, and that it's incumbent upon the parties to create a transcript or a portion of a transcript that they want to enter into the record. So I just would like this section changed so that municipalities are not on the hook to create that transcript upon request.
Okay, but we're talking about two different things, okay? We're in the section that's on the record. Okay?
Yeah.
And there are only like 5 or 6 towns that are gonna have to do this, and they do it now, and they chose to do it. And I don't want to change a single thing about on the record review. Now,
I don't think
I-
section B is the on the record section, Brooke, unless I'm mistaken. I think
No, it
section
is.
1A is the on the record portion and 1B is not that, but sorry, if I'm in the wrong section, which
No,
section
I think-
addresses municipalities
so,
without on the record?
Alex, look at H. Appeals to the Land Use Review Board on the record. And this is H1, A and B. There, it's all on the record.
Gotcha. I missed that. So, sorry. Is there a section for appeals to the Land Use Review Board not on the record?
They don't really have to do anything. You know, the towns don't have to do anything. I have de novo. I can expand this de novo section a little bit, but it's just in the rules, it's not because it's so straightforward. Now, we can say, and this is what we had in the hybrid rules, we can add in a thing that says if you want to put in the recording or a portion of the transcript, we can allow people to do that on their own. And I think that that is what we were contemplating when we were talking about hybrid.
Yeah.
So,
Well-
you know, if I'm an appellant, I can go and say, hey, listen to, you know, section an hour and 15 minutes to an hour and 20 minutes. And here's
Yeah.
what was said. I typed it out or did the transcript.
Yeah, I think
that-
I'd like that reflected, but in the on the record section as well. I don't think on the record municipalities need to be burdened with creating the transcript. They are providing electronic recording, and it should be incumbent upon the parties to have that transcribed. And the
But
reason
that's
why
what's
that needs
required
to
now,
hap-
Alex.
Sorry,
Yeah,
say
but
again,
you see,
Sarah?
it's but there's like a chain of custody kind of thing. Like you don't get to take the recording and go get it done when it's on the record review. It's the town that has to have custody of the recording, and the town sends it to the tribunal, but the appellate body. It's not
Gotcha.
like
So-
somebody gets to do that instead.
Gotcha.
So can I ask one
understand.
more question then, Brooke? And this is paragraph C, where the board can say that we can just use the recording.
Yep.
And why can't we just use the recording? Why do we have to have a transcript?
You know, it's an evidentiary issue. It's just the kind of thing that I just don't want to deviate from.
Okay.
I guess what we
Okay,
can.
It's
I'm not
okay.
saying
I
that we
don't-
don't have to, but you
And
know,
it's only a few towns and
trying to keep it real simple, right?
yeah.
They
I
do
was
it
gonna say-
here or they do it there.
We're spending a lot of time on something that rarely happens and
Yeah.
is the way that things happen right now. Let's not change it. For the few that might do it, let's just focus on other things.
Can we go to Rule 41? B?
Yeah.
And I'm just wondering if we can limit the ability for somebody to appeal the appointing of a hearing officer or a panel. Why can't we just make that decision and it's not appealable?
Yeah, I don't know. This is what the old rule said. I didn't
Okay,
create it.
well, I'm
Sure.
just it's another appealable step. Maybe we don't need to have it. It could make the process a little more efficient. You know, we can have guidelines about making those appointed, hearing officers or panels that prevent conflict of interest and other things that might be objectionable to people so that maybe there doesn't have to be an opportunity to appeal. 10 Baldwin. Is
Sorry, you probably
somebody,
couldn't hear me. That was me. So I would tend to leave in the opportunity for parties to object. I mean, it's a decision of the board and not, that's where I would go with it.
yeah,
don't-
but they can just appeal the final decision. That's appealable. Like every decision that this board makes is not something that people have opportunity to appeal. The legislature even said that once we make a determination on a plan, it's not appealable. So I don't know. Just looking for ways to make things shorter.
Well, and the other thing is leaving the opportunity just to object. I mean, okay, so the board would have to make a quick decision about it, but the board's decision supposedly is final, and that's not appealable further. But the other thing that these rules actually create is you have the authority as chair to not just appoint a panel, but theoretically, we could even have an actual hearing officer, one person deciding small issues or cases. So it may be best to leave it in there just to give them that opportunity to object if, for
Okay.
example, we went to that level of flexibility for our resources.
Yep. Okay, so Rule 32, I think Alex had a question about this last time we started talking about this, and I can't remember if we answered his question.
Yeah, I just said this is what we have in place now. So
Is
you know,
it-
it's
is
like,
it-
I don't know.
What's the necessity for it?
You know, we're at this stage, I don't think it's necessary. We can cut out the rest of the, these provisions about stays. Stays happen very infrequently, and it's, as you can see, it's pretty complicated. I just didn't really even have time to wrap my head around it. So
Just to be clear, Brooke, my suggestion last time was just to excise Rule 42B, the 7-day automatic stay, and allow people to request stays, but just not allow for an automatic 7-day stay.
Okay. And
just-
and then Rule 43, unless you need time to make a note there, Brooke.
That's all right. That's all right. I'll come back to it.
Rule 43, appeals to the board before a final decision of the district commission. Does that?
Yeah, it's a thing. It's called interlocutory appeal, where a decision is made and you have the right to appeal that to the Supreme Court before the end of the case, because it's a dispositive issue. To decide it now on appeal would save a lot of resources, because maybe there's no need for a hearing because nobody has standing, or something like that.
So are these like incomplete letters and party status, that sort of thing? Decisions?
I don't know, but incomplete letters, I think they would be JOs, but yeah,
that's
party
right.
status is typically, the kind of thing you want to appeal right up front.
What other decisions are there besides party status that would fall here?
Danny, can you come to my rescue?
Broadly,
And how
I'm
often
thinking-
does this happen?
Rarely, but I'm thinking,
Okay.
for example, if there was a preliminary decision regarding, which law applied, say there's a vesting determination that needs to be made and the outcome of the case totally changes based on which version of the law applies, and people aren't content, that would be a reason to take an interlocutory appeal to resolve that issue so that they don't waste their time going through the rest of it, only to turn around and have it undone.
Okay,
So it's an efficiency.
I see.
Yeah.
Thank you. So Rule 44, D, procedural rule. The identification of involved lawyers. I'm just wondering if that needs to be extended to other staff and board, not just involved lawyers. What, can you help me understand that? Because other staff may have been called upon to advise the lower tribunal. Is this other than just our lawyers, I mean? So does it need to be extended to more than just involved lawyers? Just a question. And that's all I had.
Yeah, I gotta give that a little bit of thought. I probably need to talk to Jenny about it offline because, it may be, I'm more concerned about the lawyers because they have influence on the board. Though you shouldn't have ex parte communications with anybody anyway, and I think that's covered elsewhere, but let me talk to her about it and see what she thinks after the
Okay.
meeting.
So, I guess, I was looking for places to cut time and I'm not sure I found any. So, but I still feel like I would like to see a range on the disposition table.
Okay. Give me some numbers. Get back
120
to
to 180, I guess. I don't know. I mean, yeah. Somebody at 10 Baldwin has their hand up.
Back on the rules of procedure very quickly, Brooke, is it your intention to include those in the attachment with the draft stamp? Like that is a draft rules of procedure, correct?
Oh, yeah, definitely.
Okay,
I gotta
Like-
separately PDF it with the draft on the watermark, and then we're
Okay.
gonna reassemble the
Okay.
document.
Just confirming, thank you.
Yeah, no, definitely. Thank you for mentioning that, for sure. So we're thinking about 180 for these, 150, 120 to 150 for JOs,
Sure.
and then 150 to 180. And then that's the one that maybe we should just say from the record being complete, just give a
Yeah.
time period.
Yeah, put an
Um,
asterisk there. Yeah. And then it
I
could be the
do
same or
90,
even,
60
yeah,
to
sure.
90 after the record.
Yeah.
All right. Does that look good?
Sarah's nodding.
I think 60's, I hate to say it, but I think 60 is probably too low. I might argue for 90 to 120. I mean, we're gonna
Yeah.
need 30 to render a written decision, right?
Yeah.
And yeah, there's gonna need to be at least 30 days from the appeal submittal to just collect the interested parties and get a hearing scheduled. So you're at 60, yeah, without anything else happening.
Okay.
Thomas Weiss has a question.
Thomas, go ahead.
My question is, aren't all the days to disposition in that table after the record is complete? And if that's true, why point it out in only the one case?
I think it's because,
No.
Thomas, the others are from when the appeal is filed. And this one is because of the transcription problem, that it may take 120 or more days
I
just to
understand.
get,
So the other top three are not from the days the record is complete.
Right, they're
So
from,
getting a complete record is built into the, for example,
Yeah.
120 to 150.
yeah,
Thank you
Well,
for the
well,
clarification.
Yeah, let me clarify further. There is no record. Okay, it's a de novo review.
right, right.
And so the appeal is filed. That's the date we start counting from. And, then we have people bring stuff to us. We don't get a record.
Okay,
Yeah.
got it. Thank you.
And Thomas, just so that you know, I am still working on your, the corrections. And so, we have in the oven number 5. So I haven't forgotten, the listings that you provided. So.
Okay.
Was there one
Thank-
more thing that you wanted to come back to? Alex?
Yeah, but I'm done. I don't think we need to trash this anymore. It was the hybrid
Okay.
review. The hybrid review was the last thing I
Oh,
was saying.
okay.
Hey, let's put that back in, but let's just move on.
Okay. All right, Brooke, what do you think? Do you have, do you think, Monday, this will be fully baked and ready for a decision? Okay,
Yeah, what I'd like to do is get it, I do not know that we can get it posted tomorrow, but we can get it posted first thing Monday morning and I can send it to the board over the weekend. I'm hoping for like Saturday, late Saturday, so that you have at least Sunday and Monday morning to look at it as a final run through. And then I would like to, hopefully it'll be, ready with any other last minute changes. And then we can have it actually transmitted on Monday. And if we make the decision, I can hopefully have Alex P waiting in the wings, to actually get it out to the legislature. And that'll be 1 week beyond the deadline.
yeah,
But I think it was worth being late with it because there were just improvements I couldn't get to.
Yeah.
And I'm working on the icing now. It will be improved.
great, thanks. Sarah?
So we keep on coming back to the cake analogy, right? And the baking, whatever. And you have a magnificent wedding cake at this point. So it's like multiple tiers and all fancy. And thank you, because I think particularly with the appendices and the rules and what's come together over the past week, well done, and good things take time. So thank you.
Thanks.
A
Appreciate
tiered
it.
wedding cake.
And thank you for your patience with this. I know it's been, I wish I could have had a clone and worked a little faster on it, but it's been a lot. So,
Yeah.
thank you for all of the feedback and the collaboration and the consensus. I think that is important.
Great. Thank you, Brooke. All right, let's move along to the Rutland response. I think, let me just make sure I'm remembering the agenda. Yep. So, have people had time to look it over? Thumbs up. Sarah, you have your hand up.
Yeah, I've had some time to look it over, and thank you, Janet. Again, the first one in, that's a really tough, you're the icebreaker on this, and so I think a lot of us are looking to you in terms of process and improvement. I think the one thing after reading what you sent out and my own review, and I haven't heard you speak to yet, and I wanted to hear you speak to it, was the inclusion or the not inclusion of the variety of different comments that we received in the portal from some of our sister agencies, from some of the municipalities. There's some substantial things. Some of them line up with some of what we are recommending. Some of them do not. I think that's something that before we close the chapter on this, I wanted to hear how you incorporated or did not incorporate in the process.
They are referenced in the letter and in the first paragraph. And I think our job was to collect them and to, make sure that they could be provided to the RPC. I don't think it was our job to summarize them or to necessarily incorporate them in our own comments. Does that help? Do you want to discuss it any further?
No, I just, I think what I will say is, there were, I think some unresolved issues from municipalities that, made their way into the process. And I'm not sure if the municipalities are looking for us to provide the regional plan with guidance if they have unmet needs that the RPC is not addressed. There are some of those from a variety of different towns that I just didn't see us as commenting on one way or another in terms of if they were potentially things that could meet or could be an improvement, or just trying to sort through those. There were a lot though to get through.
There were a lot, and I think at least half, if not more, were all the misdirected advocacy to have the board give Tier 1A status to a project in Killington. So then there about half of the comments that came were that, and then there was a whole slew that came that were concerned about the board's potential interpretation of village areas. A whole bunch came at that, but I'm not remembering any that were from municipalities suggesting that the RPC, wasn't properly advocating for them.
I think there were just some slight differences, and I'll pick on, I think Mendon had some with the recreation area. And then I think it was one of the Paulettes too that,
Oh, you know what? The Mendon, so there was something about Mendon, and I asked if they had addressed those concerns, and Mendon said they had. And Paulette, there was one comment from a citizen and official in Paulette. Yeah, but again, I don't think it was our job to answer all those comments and to incorporate them. I think it was our job to collect them and make them available to the RPC. Ten Baldwin.
That's me again. So just a couple things. Janet, you asked if board members had found time to read through this reorganization and updated version. And I found time to read about 3/4 of it. I'm not quite finish line. I found it more readable and like organizationally flowed better to me than the last version and organization. So thank you. I wanted to follow up on my question I had about the certification concerning the municipal flood hazard and river corridor bylaws, compliance with the relevant statute. And I did take a closer look at the pre-application plan submittal, and I did find, I was looking at the RPC content, and I did find what I was looking for within the municipal certifications. So I'm all set with that question.
Okay. Alex, I noticed your hand was up at one point. Did you put it down or did it fall down?
Well, I put it down. I do have comments on the draft. I don't know if you want to take specific comments now or you're still going through the general stuff.
I'm happy to do both. Brooke, do you have a general comment?
Yeah, and I'm trying to find it. I think it was number 9, goal 9. I just had
Right.
one comment, and I wasn't if that's the right one. And maybe it wasn't. Anyway, there was one, and I have to try to find it. I highlighted it that wasn't clear to me whether or not they passed or failed. So
Okay, yeah.
I'll shut up and go find it.
Okay, well, let's show the screen. Let's see. That's oops, shoot. Okay, can you see it? Hello?
Yes,
Okay. Is it large enough? It might make it a little bit larger. So,
Yeah, if you can maximize it a little bit more, Janet, to fill the page, that'd be great.
okay,
Just
Like
for
that?
folks in the room here.
Thank
Yeah.
you.
Here's, Sarah, the link to the database, our state partners and public comments be found here. So let's go to 9. Goal 9, I think, is it housing? Goal 9. Oh, no, that's agricultural and forest industries.
Jana, I have it on page, looks like 7 of the decision.
Yeah. That must not have been it. Maybe it was element 9. That was the housing element. Brooke, do you want to go there?
I'm not sure. I'm still looking for it.
Okay, I'm gonna go to housing because there were some okay, 9, housing. The draft regional plan must include. It includes certain things. Requested revision, the board asks the commission to consider including more discussion about how it plans to achieve 85% of new housing units as affordable. That was added based on our conversation on Monday. And then we had also discussed before submitting the adopted plan, the board asked the commission to include more discussion of the justification for its proposed housing targets. That is, why did it not use the statewide housing needs assessment? And why did it use the mid-range for the regional? We're not telling them that what they did was wrong. We're just telling them that we need more justification provided. And then finally, we asked that they provide more description of their methodology for municipalization of housing targets. And then there were a couple of advisory recommendations. And so one was that they consider using some tracking the number of perpetually affordable units and other sort of tracking numbers to understand their progress as the years go on here. And the other was some clarification about whether they are proposing that infill development in flood hazards should occur or not. So this is a little tricky because I think there's gray area at this stage. And I think that I settled on this requested revision for the things that the board really wants to see this, right? And the other advisory recommendation is just, you know, you could do this. It might make a better plan, right? And so I didn't say for this housing element that it was met or not met. And So was that your sort of,
Yeah,
Um,
I was just, I was afraid they would be unclear whether this was, like, you didn't pass yet and you have to do these things to pass, or, I mean, I see the difference between the requested revision and the advisory, suggestions. It just seemed like that was the one that didn't really plant your feet on whether whether they had to do this or not.
yeah, I think they could make a case that they meet the requirement. And I don't, I'm not, um, I'm not convinced that they failed. And I don't know if any of the rest of you are. Um, you know, they're, the conversation about this 85% being a really tall order. It doesn't necessarily mean that they failed, but maybe it deserves some attention, right? Um, uh, Sarah, do you have something to add here?
Yeah, I think it's completely appropriate where we're at to be in the tell me more stage is, on face value, they are meeting the target and they're appropriately dividing it amongst their various different communities. I think we can note some things as being overly ambitious, and please tell us more how you plan to accomplish this. And again, affordable being up to, I think, 120% of median household. And so it might be that there's an analysis of existing housing stock that there's already a lot of what's being built is affordable, and that would be a good counter to it. But I think at this point, it's just please tell us more. We'd love to hear it, and that will help us make a determination on the actual application when it comes in.
And actually, Brooke, up to the future land use map, I think there was only one area where I said the plan does not, or no, two areas where the plan does not meet. And one was the goal 15, the equity analysis, and the other was under the which goal was it? That historic and natural resources. I found that there was no mention of fragile and significant natural resources, and that there wasn't a whole lot of identification of what the region's historic resources were. So, and I think that they could be easily satisfied, perhaps, by a map. And there may be fragile and significant natural areas that you don't necessarily want to map. So I didn't suggest a map for that, but we can look at that if you want as well. Let's see. Yeah. So here's goal 15. And these are the requested revisions. And so I think it's important that we as a board agree about this one, because I felt that it did sort of fail to address what goal 15 was addressing, because they didn't provide an equity analysis. How do others feel about that?
I
Sarah?
agree.
Brooke, I heard you.
I agree with you. I'll just say
Yeah.
that.
I think they did a lot. I think
Yep.
they did quite a bit, but it's in the appendices. And I think everything that we heard was they did such a great community outreach and involvement. And I think I noted in some of my reviews, some of the different populations that they did engage with. But again, having it be in the appendices as opposed to the actual report, I think there could be some more to strengthen it. And it's just a matter of connecting the dots or leading a breadcrumb trail a little bit better to help with that explanation. So hopefully nothing, again, too onerous for them. I see this as something that they should actually speak to their efforts of what they did more. And I think that they can get that across the finish line and it will be better for it.
Yeah, just to be clear though, I don't think that they even had it in an appendix. They did not provide an equity analysis relative to environmental justice focused populations. They
Sorry,
provided an equity analysis presentation that they gave as a PowerPoint, but it was just a general, this is what an equity analysis is.
But there was also beyond that, and maybe it was within their submittal, but not necessarily appendices. It was quite a lengthy
So their
public
engagement
involvement.
process. Yeah,
Yeah.
yeah. Which I also say elsewhere that they did a commendable job on, and that was a different section. This is specifically where's goal 15. Requires the plan to equitably distribute environmental benefits and burdens as described in 3 VSA chapter 72. And that it is further policy of the state of Vermont to provide the opportunity for meaningful participation of all individuals with particular attention to environmental justice focused populations in the development, implementation, or enforcement. I think they did a great job of centering equity as a principle. They just didn't show us that they conducted an equity analysis and looked at a distribution of environmental benefits and burdens in the region. Somebody, I presume Kirsten, has her hand up.
Yep, I agree with you, Janet. I mean, I agree with everything everyone has said about this. So I'm fine with the way it's drafted now. With respect to this.
Okay, great.
Equity
Alex?
analysis component in the school.
Yeah.
Yep.
Yeah, so I'm with you on the general comment or decision point. But I would say that in the third bullet, minor wording change suggestion, it says include a summary of engagement strategies focused on disadvantaged groups and how the RRPC reached these populations. I would change that to and how the RRPC has reached or will reach these populations. Because presumably, they may be doing more of that. So a little bit of tense there.
Right.
More significantly, in the next two bullets, the last two bullets 4 and 5, I think these are saying the same thing, and I would recommend deleting the fourth bullet.
Okay. Instead of which one's the fourth? This shorter one?
The one that says outline a plan for routine engagement. I don't want to hold them to that. And I think the last bullet is enough.
Yeah, I agree.
Hey, Janet,
Thanks.
that prior bullet, you put the word of, not or.
Oh, thank you.
As reached.
Oh, I saw that in your report somewhere and I circled it. If you want me to find it for you.
Let me know where it is.
Yep. Where's that?
I don't want to search for of.
Yeah. But I do want Rutland to know that I think they did a great engagement program. And so I can't remember now, maybe Rebecca remembers, because Rebecca was right there with me on all this, getting it in here. So but I did applaud them for their engagement
Yeah.
program.
We have some input from Maddie here in the room.
Maddie?
Yeah, I just wanted to flag, it was brought to my attention that the link that is at the very top of the document that links to it's supposed to link to the public database, but it's currently linking to the internal side, so apologies for that. That's my error. And we'll fix that when we go to issue the final letter. But if you
Okay.
do need to get to the database, there's lots of ways to do that through our act250.vermont.gov website. So just wanted to bring that to everyone's attention.
Thank you, Maddie.
Yep.
So the other place where did anyone want to see the other place where I found non-compliance? It's right here. The draft plan does not sufficiently identify particular historic and cultural resources as required. There is some, and there's mention of that one particular haunted house. It got a whole sidebar extra page, I think. But there was no map showing historic districts or a broader conversation about it. And then again, significant natural communities in fragile areas. Is that what this? Oh, you know what? I don't want to say communities here. I'm going to take it out if that's okay. It was significant natural and fragile areas that the statute mentions. So, Alex, your hand went up and then back down.
I was just waiting for you to get through your piece before I give you more comments.
Okay, let's go. More
Okay.
comments.
Ready?
Yep.
Page 2.
Oh, okay.
Goal 1. And this is actually a general comment, but I just wanted to use this as the example. So on many of the goals, you have preamble that explains all the good things that the plan does to address the goal. And then you conclude with it meets the goal. But on some of the goals, there's no preamble and it just says, here's the goal and it met the goal.
Yeah.
Can we just make it short and sweet without the preamble? Or do we need that paragraph in some of these goals as, I don't know, some sort of,
Findings.
yeah, do we need that for our eventual final decision, in 90 days or 120 days or whatever? Is that why
Yeah.
all that language is there?
Yeah. I think
Okay.
so. And also to give some positive feedback to the regional commission.
Yeah, well, I think, they're high functioning adults and they
I know.
don't
I
need a
know, they don't.
recitation of
It's
the
true.
goal and then how they met the goal and then a statement
true,
that they
but
met the goal,
But we do need to provide findings for our final decision. And my hope is that this pre-application response will help us do that.
Gotcha. Okay, not going to quibble with that. And I'm not asking you to add more preamble to goal 7 or goal 15
Okay.
that doesn't have any. I'm just commenting that if there was a way to shorten this, I would
Yeah.
I would approve of shortening.
Yeah.
Let's see. I'm trying to not talk about any wordsmithing things. Okay, next one, page 19.
Go ahead.
So the requested revision is the methodology for municipalization of housing targets should be more thoroughly described within the housing element narrative. Does it? I don't think it does. I think they indicated what factors were considered, and it sounds like what you want is a formula, and I don't think we need a formula. I think understanding what the factors are is enough, but that's my comment.
I just want a little more description of how they settled on you know, the numbers that they settled on. I don't want a formula. I mean, yeah, I don't know.
Okay, well, I'm just giving you my comment.
Yeah,
I would get rid of that requested revision. I'm satisfied with the factors that they listed and happy to leave them to know
Do you
the
want-
exact recipe.
would you be happier if I made it as an advisory recommendation?
Uh, your choice. I don't care. I just wanted to get the comment in and I'm happy to defer to you, as you can tell from my prior comments. I'm just trying to
Yeah.
make comments, take them for what they're
Okay.
worth.
Okay.
Let's see, what's only a couple more here. So page 22.
The strange thing is that the pagination is different when you print it than when you, so what exactly on page 22?
Downtown centers. It's the beginning of the downtown centers discussion.
Okay, got it.
And the first sentence under that, the second sentence says downtown centers are required to have zoning and subdivision bylaws and public or water or sewer services. We talked about this at another time, and I was pointing out, I don't see that in statute. And you pointed out, well, it says village centers don't have to have those things. So it's implied that downtown centers do. Is there a way to say that, or because I'm still not convinced that the statute is clear enough to make a declarative statement like this. I think that it could be questioned, and there's no statutory reference for it. So why are we saying that? Sorry, how do we justify that we're saying that?
Rebecca, are you present?
I am. So we use so we use id after it, which means we're citing back to the previous citation. So we are citing to that section
5803.
12A. Yeah, where no, not 5803, 48, 40, 43, 48A, subsection A, subsection 12, subsection A, where it does give that, there's so much, Alex, about this process where we were wishing for some better legislative language with it. And so I think the other thing, when you look at that site, I don't know if I can, I think it's in 5803, right? And it talks about, when the Community Investment Board looks at downtown centers, it's got like 12 things specifically that downtowns, or not, maybe not 12, but it has several things that downtown centers need to have, which include and in addition to the ones we have listed here, zoning and subdivision bylaws and public waters or sewer services. So I picked the safest method here is because we're not the Community Investment Board. So in our statute, in this part of our review process, where it says that village center doesn't need these things, it doesn't say that downtown centers don't need these things. So I don't think we can ignore that fact, because if they meant to say that downtown centers, I mean, the whole sentence just wouldn't be there, right? Like, so what's the purpose of the center if, I'm not
The
sentence,
downtown,
if,
yeah.
right. And so the two together make me feel that we're being reasonable in this, and we're not going too far by saying, and we want to see everything in step 3 of 5803 as part of this process, which we're not asking for.
So I guess as much as I don't want to quibble, because you're the lawyer, I'm not. Maybe it would make sense to not just use id in that after that sentence.
Yep.
Perhaps it should be referencing both 43, 48A, A, 12A, and 5803.
Yep,
Would
I
that
can do
provide
that.
more context for the reader?
Yep, I could add that in there. And I could also add, so Jan, if you just highlight that, I'll do that as you guys, right.
I just did it.
Perfect. Yep. We could
Or
also add,
Alex, do you think it needs to be 12A? You know,
it should
do you
be,
think,
yeah, it should be subsection A as well. Because we're talking about that specific sentence
wait,
at the end of it.
this is, sorry, this is,
Oh, wait, sorry, not 50.
that's the wrong,
Yeah,
yeah,
pull the one
I'll-
that's the,
I'm gonna make it yellow and you can fix it, Rebecca.
absolutely. Yep,
Sounds good. Thank
Just
you
check
both.
that too.
yep, you're welcome.
Okay,
So the next one is on page 23, which is village centers, which starts with a little bit of text and then it goes to Benson. And my question here sort of extends to a lot of these, which is I want it to be super clear in the what we provide to the RPC, what is required, like where did you fail and you have to make a change, and where is it advisory? And you did a great job everywhere else in this document of clarifying the difference between those two, but it wasn't clear to me if I guess you're intending these requested revisions to be more serious, not advisory, yes? Or that was my
I
question.
don't know. I mean, I feel like, there's gray area.
Yeah,
And-
because a lot of the comments are, include whole parcels,
Yeah.
make it wider. I'm not sure that we would flunk their final application if they chose not
Right.
to do that. I think we probably would still accept it. So it feels
Right.
like they're actually advisory, but it doesn't say that. The formatting makes you think like you have to
Yeah.
change this or else.
Yeah,
So maybe just consider making those all advisory recommendations.
yeah, I think that's a good point.
Yeah, that's an area too. Let me just jump in that I'm feeling very uncertain about myself. I was unclear on that. I'm only seeing black and white, no gray yet. I need more.
I think part of what Rebecca sort of advocated here for me was that the methodology, the VAPTA methodology is also something that we looked at, and there was some suggestion in the methodology in some cases to include whole parcels. But it's not that clear in the methodology either. And I think there are some cases where the narrowness of what they are mapping, particularly the planned growth area in Castleton, didn't have the depth to be a meaningful, useful planned growth area. So yeah, there is gray area here. This is the first one. It was really hard to sort of settle on. Sarah, do you have some helpful?
Well, I think this is one of the perils of going first, is I think in reviewing the VAPTA methodology, and I was reviewing that against state statute, is there's a lot of maze and advisory within and I think this is a placeholder for later, where the VAPTA methodology, I think there are 4 versions this spring. Maybe after we get through a couple of these plans, we could have a conversation with them about a 5th version. And I want to respect that there will always be regional differences, and there might be really good reasons why. There might be parcels, but I think that clearer guidance within the VAPTA methodology for future land use areas might be beneficial after we get through this first wave.
Yeah, and I do feel like in most cases, where they bisect parcels and they have very narrow growth area depictions, that they really should include the whole parcel unless it's a very large parcel. It just doesn't seem like it will have meaningful effect if it isn't, if they don't be a little bit more expansive. They tended to cut all of their planned growth areas right at the edge of any mapped sewer service. And I don't think that they should do that. I think they should be more expansive.
I don't know how else to help you on that, Janet, but I hear your point. And if you want to leave it as the way it's drafted, which implies that it's a necessary change, not an advisory one, then, you know, I'm okay with that. Just, you might
Well,
get
I
some
will
comments from
say
them.
that the only one that I pointed out did not meet statutory requirements is this one, Killington. As mapped, the proposed Killington Village Center does not meet the requirements for a village center. The
Right.
others, you know, they're fine, right? This one was not. And these are only advisory recommendations because, I mean, they can choose to do something different. This is just one way they could look at it. But they can't come back with the same village center, in my opinion, and get an approval. And so
Understood.
that's why this, you know, is stated. And I don't think that I said that almost anywhere else, did I? Except for Fairhaven, which doesn't yet have its subdivision regulations, right?
Yeah.
So, yeah, the rest is gray area.
Yeah, so however you want to deal with the formatting of whether it's called a requested revision or
Yeah,
an advisory recommendation, I'll leave that to you. I just wanted to make the comment that its clarity is good, and we want the recipient to know like what they must do in our mind and what they, you know, what would be nice if they did, but not necessary.
yeah,
So I just a couple others, and then I promise to be quiet.
it's okay.
So let's see. Um, I don't know that you want to change the wording, but on page 34, resource-based recreation area. Are we there? Yeah, it mentions
there.
that in the second paragraph that they're proposed in certain places. And in those places, like Lake Bomazine, it's the entire lake and everything around it. And I will just note that when we reviewed the Northwest plan, they noted that they weren't following that protocol, and that purely residential areas around a recreational resource were not being mapped in this particular FLU. So which one is right? I'm not sure, but when I read the definition, you know, of a large scale resource based recreational facility, often concentrated around ski resorts, lake shores, or concentrated trail networks that may provide infrastructure, jobs, or housing to support recreational activities, it's a little gray again. Like, does that really mean a lake that has camps around it? I don't know. So again, you may not, you maybe don't need to change any of the wording, but I just thought for the board, we might want to be thinking about that a little bit, because I imagine each regional planning commission might take a slightly different approach.
Yeah, yeah,
I'll leave it at that. It may be a distinction without a difference, given that these particular FLUs don't have a lot of import, frankly. And then on page 36, this is in the rural section, and page 36, there's a paragraph that starts mapped wetland and flood hazard area exclusions.
yeah,
What I'm concerned about is that if it sounds like what you're saying is if it's a wetland area, it needs to be rural conservation. And I disagree with that. There are
Yeah.
plenty of small mapped wetlands that can be right in the middle of a downtown or a planned growth area or any other FLU that should not automatically become a little hole of rural conservation just because they're on the
Right.
wetland map.
Right. In fact, that was part of the problem I meant to address is these tiny little, you know, rural conservation, because there's a wetland there, it really should be subsumed by the surrounding. So, yeah, I agree with you. You know, you get a little lost in all that you have to cover and you kind of forget what what I wanted to say about this. So,
Yeah, well, you said it was inconsistent. You said
it
some
is, yeah,
wetlands are excluded, some are not. I think maybe you can say that and then follow that with a sentence saying, small wetland areas should be included in the surrounding FLU and not their own, rural conservation FLU as an inholding.
yeah. Can you think of a way to add some wording right here that would address that?
Yep, I'll send you a sentence.
I have to get this out tomorrow, by the way.
Yeah, I'll
So,
send you a
okay.
sentence, today.
Okay, thanks. All right,
I
anything
think that
else?
I think that was largely it, except one of my comments I made to you early on was that overall, there are some overall mapping issues that aren't specific to a particular FLU type with regard to slivers and
Yeah.
roads getting mapped as rural general, even when they're passing through a rural conservation area.
Yeah, and I meant to include that in this section too. You can see this, I guess I got a little tired by the end here.
Totally understandable. I
So,
can send you some sentences on that as well if you want
okay,
to
that'd be
take a
great. That'd be great. Rebecca?
Just as an idea, Alex, are those comments related specifically to like within the rural category, or would it be like in general for like all mapping? Because one way, excuse me, one of the places we could think of putting it is actually in the beginning of the section, because it first starts with subsection 12 that just talks about like, and then we go into the mapping. So we could put it just as like some general, if it applies to like the entire map, not a particular category.
I think it
Yep.
usually, though, it usually happens with these rural categories.
Okay, that's just because I just wanted to make sure, because if it was broader than just this category, it would also fit before we get into all the subcategories.
I
Yeah.
agree with Janet that usually it's in the rural
Right.
categories,
Okay.
but
But
it's
not
really
always.
it's really a general comment that I would actually think more appropriate at the beginning of the section,
Yeah.
because it speaks to how they did their mapping methodology, not so much just one FLU.
Yeah. Sarah?
So maybe Monday, we can talk about it more under reports or something of that nature, but I would love to have a conversation before Kirsten and I submit for comments for the board for the pre-applications for the next two regional plans. Just a bit of this formatting and how we're going to tackle this. Because I would agree that I think some of these comments could be made once generally in these categories and then not need to be repeated again. Just to try and get the length of this down, because it is understood we have fulfilled our duty, and Janet, you're not out of the park. You had something under everything, but this is a lengthy response that just I
Pretty
worry about.
lengthy plan.
Well, I worry about accessibility for both for the general population. And so I think it's worthwhile the board having a conversation, not now, but maybe Monday might be one, just in terms of lessons learned and what we might want to change looking forward.
I did, so, Alex, consider connecting small pockets of rural general areas to result in areas with more depth and integrity where the mapping methodology has resulted in isolated pockets of rural general areas, consider subsuming these areas in one of the larger adjacent rural categories. And where these areas fall within river corridors and flood hazard areas, consider changing them to rural conservation to reflect the importance of protecting these corridors. So that was sort of trying to address the isolated pockets and small things, small pockets, but I think you're right. I think there were others in other categories that happened. So
Yeah, there's some slivers
yeah,
all over the place.
yeah. So, and I didn't address the um the roads. I could say such as roads.
Send you some language, Janet. You don't have to do it now unless you're really married to it.
All right. Anything from others? Ten Baldwin.
This is Kirsten. So I'm just wondering if we as a board have a benchmark with respect to distance and walkability, where I've seen, you know, a quarter to a half mile referenced, and I'm just wondering when we are evaluating walkability, what does that mean for us as a board and in terms of applying these standards? I'm interested to know what the other board members think and
So I
how
think
they're
that's-
evaluating that.
I think that is a question that maybe we can ask generally. And I think what we need to do today is we need to discuss this particular response and adopt it as a board so that it can be sent out tomorrow. But I think that's a really important question, Kirsten. And, you know, for this Rutland region, I think it was pretty clear that Killington doesn't meet walkability the way they mapped it. And we had some conversations about Castleton, but because they show sidewalk all along that way, I think we maybe assuaged Sarah's concerns that was too long and not walkable. Is that right, Sarah? Last Monday when we talked about this, but I think it's an important question, Kirsten, but I don't think we should have that conversation now.
Right, and I think that's again something to talk about in consideration for the next versions of these, because I think there are some that you could take a look at some of the interim exemptions between that quarter mile and half mile around existing centers, that 15 minutes walkability. I think there's some stuff there that we could probably pull from. But I was just going to ask you what your pleasure is. Do you feel like with the changes that you have that you feel confident having us vote on this with the changes discussed here today?
Yes, I not just confident, but I feel like it's imperative that we get this out. And so if the board feels comfortable doing that with a few outstanding revisions, Maddie can fix the link. Rebecca can make the citation that we discussed, and Alex has some wording that he's going to send me regarding the de minimis part, de minimis mapping, maybe. Is that Kirsten?
Yes. So tying my question back to the Rutland plan. I guess I just want to note for the record that I think there appear to be some areas that don't strictly meet the walkable. We may not strictly meet the sort of walkable standard element of the, a couple of designations. Like planned growth area has that, baked into the standard. And I just don't want to have this review establish like a precedent for how we do or don't evaluate that factor moving forward. I think this is our first one. So if we can have that understanding, that will, and I agree with Sarah, I think a general conversation before we queue up the next ones will be very helpful.
This may help a little bit, Kirsten, but at the beginning of this and at the end, this pre-application response is advisory only and does not guarantee an affirmative determination. But I guess I would also ask which planned growth areas are you referring to, and do the comments in here address your concerns?
I'm not sure. I mean, in terms of whether or not the comments, I don't think that we have done a thorough review of sort of walkability of the different designations where that factor is in, is relevant. And so at least, I've done some sort of piecemeal, but I haven't frankly found the time to do the level of review with respect to that factor that I would have liked to do. So I know that you, Janet, have put, more time than anyone into this, and everyone's contributed what they can. So, I'm fine with getting this to the finish line and getting it out the door on schedule as, we need to maintain our process. I think Pulteney was in question in my mind as far as just the walkability element. And I know we touched on that briefly at the, we've already had a lengthy discussion about some of these. So I don't know that we need to belabor it further, but I just wanted to note that with the next one, I myself want to do and plan to do a more thorough assessment of the walkability.
Sarah?
All right, don't shoot me, but I do want to just ask the question of, we do have the deadline of tomorrow. I think we can ask our PCs for extensions. And just given the length of the meeting where we're at, and we are punting appeals to Monday too, just to make sure that we get everything right, because it's important. And I think this is very important as our first regional plan. I just want to throw out there, if there is a possibility of asking Rutland for
There
postponement
was-
until Monday.
There was a possibility. In fact, I did ask and the answer was no. They can't make it work. They need it tomorrow.
Yeah.
Well, how about we just call it good with the changes that we discussed today? I can put that in the form of a motion.
I would accept that, Brooke, before he puts forth a motion.
Yeah, I just want to understand if we have concerns about like not telling them that you did or didn't pass, as a village center or whatever. I mean, I think you're asking for revisions. And to me, that's different than just advisory stuff. So I think what I'm looking at conveys appropriately our concerns about the depth and, maybe the walkability is not articulated specifically. But am I on the right track in terms of the message that we're sending?
Yeah, I think so. And I can tell you that I did, I spent hours dropping the little Google person in every single center and planned growth area and walked around and looked at stuff. Given also that I know parts of this region fairly well because I live just south of it. But it doesn't mean that it's walkable from one end to the other. It means that they have sidewalks. They have a commitment to extending their sidewalk infrastructure as they grow. And I think, including these whole parcels and whole blocks, these comments are part of making an interconnected, walkable center. And so I think that was something that I definitely looked at as I really inspected this map. So I don't know if that helps, Kirsten. But
It
yeah.
does, and thank you for explaining that. I appreciate that, knowing the time you spent considering walkability, so thank you.
So I'll make a motion that we authorize Janet to make the revisions that we discussed today and send the response.
I'll second it.
Thank you. Any discussion from anybody before we vote on this? Okey doke. All those in favor, please say aye. Aye.
Aye.
Aye.
Hi.
That is 5 ayes. It is unanimous. So I will finalize this with Alex, Rebecca, and Maddie tomorrow morning, and we'll ship it off. Thank you for your input, everybody.
You'll be glad
Thanks
to
for
get
all
this.
that work.
Yeah,
Tremendous amount of work. Thank you, Janet.
yeah, thank you,
Yeah.
Janet.
Can I
And-
just say, we have all done a tremendous amount of work. And we're all doing a tremendous amount of work. So thank you, everybody.
Yay! One thing
One down,
accomplished.
one thing accomplished. 2. Forest
One
Products
down.
was
We're close.
accomplished.
We're close.
Yeah, 2, almost 3.
One down, 10 to go.
Yeah, one of these down, 10 to go, and then the final.
11 more.
So really, it's 20, 22 minus 1. It's 21 to go. All right. What else do we have on the agenda? Hold on, I gotta change windows.
I'd like to make a motion.
Okay, go
The
ahead.
board needs to discuss pending and probable Act 250 appeals and enforcement actions, personnel and staffing matters, and to have confidential attorney-client communications on these matters. I move that we find that premature public knowledge of these matters would place the board at a substantial disadvantage and the board enter executive session.
Second.
Brooke seconded.
And it would also add that it would be appreciated if we could have a little bit of a break going into it, just given the
Yeah.
hour and the length of the meeting.
Yeah, thank you. I think let's take a 15 or let's take a 10-minute break and convene in executive session at 5:15. Doke. Thank you.
Aye.
Call the question,
Did we-
Janet.
We got a vote.
What?
Yeah, vote on the question.
Aye.
Oh, I'm sorry. Sorry. Yeah. All those in favor, please say aye. Aye.
Aye.
And we will return. Have no doubt that we will return to this meeting when we are done with the executive session.
Oh, you're
See you
moving.
soon.
I think we just have to wait for Kirsten.
And probably wait for the in-person location.
Yep, okay,
Yeah,
there we go.
Should be good here. Yep.
So we're back on the record, and I'll just note that Janet had to step out. And so with that, I'm assuming hopefully adjourning the meeting. I'd love to entertain a motion.
Motion to adjourn?
Brooke?
Second.
Oh, I think Kirsten got for you, Alex. All right, all those in favor signify by saying aye.
Aye.
Hi,
All right, and we're adjourned. Thank you so much. Have a good night.
thank you.